But under this law, crimes such as aggravated batteries, robberies, burglaries, hate crimes, aggravated DUIs, vehicular homicide, drug-induced homicides, all drug offenses, including delivery of fentanyl and trafficking cases, are not eligible for detention no matter the severity of the crime or the defendant's risk to a specific person or the community unless people prove by clear and convincing evidence the person has a high likelihood of willful flight to avoid prosecution. What the f? They even had the
You know how sometimes there's those moments where you could be shocked, but not shocked. This is one of those moments. So I'm surprised that Colion Noir, a lawyer who did not read the context of this bill. Don't get me wrong. There are some horrible parts to this bill, but there are some great parts. But the one thing that we must be in the 2A and law enforcement community is good stewards of the information by not fanning the flames of fear. You don't fan the flames of fear to try to gain support, because that let's just get to it. So I'm gonna show you where Dr. Noir is actually wrong. If you actually go to House Bill 3653, which is actually the Safety Act, right? Like I said, there's some horrible parts of this bill, but I'm going to go on ahead and address the specific claims that Mr. Noir made in his video. He stated words to the effect, and I just want to make sure I get them wrong, because it's obvious that he is not speaking out of his own mouth per se as though he wrote this. He's reading it from an article, right? And it says under the new law, entire categories of crimes such as aggravated batteries, robberies, burglaries, hate crimes, aggravated DUIs, vehicular homicide, drug-induced homicides, all drug offenses, including delivery of fentanyl and trafficking cases, are not eligible for detention, no matter the severity of the crime or the defendant's risk to a specific person or the community, unless the people prove by clear and convincing evidence that the person has a, quote, high likelihood of willful flight to avoid prosecution, end quote. That is so further from the truth. And you clearly see the statute right here. Now, what you see is the bill with the strike throughs and the add-ons. The strike throughs are obviously lined through, and the add-ons are what is underlined. Instead of it being bail, it's now going to be called pretrial release. Upon verified petition of the state, the court shall hold a hearing and may deny a defendant pretrial release only if, one, the defendant who is charged with a forcible felony, you clearly see it right here, forcible felony. What are those forcible felonies? Treason, murder, any kind of murder, first degree, second degree, predatory criminal sexual assault, aggravated criminal sexual assault, robbery, burglary, residential burglary, aggravated arson, aggravated kidnapping, aggravated battery, right? Now it provides specifics on this. A forcible felony for which the sentence of imprisonment without probation. So that means those offenses that he listed are probationable if you have no priors. Now I'm surprised Colion Noir, as a lawyer, did not bother to read the text of the law, which is just, oh my, that's, come on, Colion, you got to be better than that, right? Periodic imprisonment or conditional discharge is required by law upon conviction, and when it is alleged that the defendant's pretrial release poses a specific, real, and present threat to any person or the community. So I thought you just said it didn't consider that.
Are not eligible for detention no matter the severity of the crime or the defendant's risk to a specific person or the community.
And when it is alleged that the defendant's pretrial release poses a specific, real, and present threat to any person or the community. So I thought you just said it didn't consider that, when the text of the law and the amendments clearly say that. Here's section A, 2 through 6. The defendant is charged with stalking, aggravated stalking, right? And it is alleged that the defendant's pretrial release poses a, again, real and present threat to the physical safety of a victim of the alleged offense, right? And the denial of release is necessary to prevent the fulfillment of the threat upon which the charge is based. Here we go. Number 3, the victim of abuse was a family member or household member as defined in Section 103 of the Illinois Domestic Violence Act of 1986, and the person charged at the time of the alleged offense was subject to the terms of an order of protection entered under Section 112A-14 of this code, or Section 214 of the Illinois Domestic Violence Act, or was previously convicted of a violation of order of protection under Section 12-3.4 or 12-30 of the Criminal Code of 1961, right? We can continue reading this verbatim. Let's get down to Section 4, charged with domestic battery, aggravated domestic battery, same conditions, right? Charged with any sexual act under Article 11 of the Criminal Code of 2012, okay? And the defendant is charged with any of these violations under the Criminal Code of 2012, and it is alleged that the defendant's pretrial releases pose a real and present threat to the physical safety of any specifically identifiable person or persons, right? You got aggravated discharge of a firearm, all these different weapons offenses under Section 24 of the Illinois Criminal Code, right? Gun renting, firearms trafficking, right? Now, the thing is that the state actually has to do a petition, no different than what they would do anyway, right? What is that petition? The petition has to have a few things in it, right? The petition shall be verified. This is under Section 110-6.1. What letter is this? It would be C2, okay? The petition shall be verified by the state and shall state the grounds upon which it contends the defendant should be denied pretrial release, including the identity of the specific person or persons the state believes the defendant poses a danger to. You know what else has specificity? The 4th Amendment to the United States Constitution. It states the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation. What's that word after that? Specifically listing the place to be searched and the persons or places or things to be seized, right? So there's always been specificity. Instead of just it being broad, they added a specific component to this. Let's get down to it. Here we go. The state shall bear the burden, right? We're right here. The state shall bear the burden of proving by clear and convincing evidence that, here we go, the proof is evident or the presumption is great that the defendant committed an offense as listed in the above paragraphs, Section 1 through 6. Okay? It doesn't ignore the community. If you go back up to Section 1 through 6 of subsection A, if you read, you will clearly see that it says a specific person or persons or the community. Stop making up shit to fan the flames. Here we go. The defendant poses a real and present threat to the safety of a specific identifiable person or persons by conduct which may include, but is not limited to, a forcible felony. Didn't we just go through those? Right? The obstruction of justice, intimidation or injury or abuse, as defined by paragraph 1 of Section 103 of the Illinois Domestic Violence Act. And the court finds that no condition, well, that was stricken through, right? But no condition or combination of conditions set forth in subsection B of Section 110-10 of this article can mitigate the real and present threat or to the safety of any person or persons or the defendant's willful flight. You know what defendant's willful flight could be? When they resist, when they run. If you actually listen to Illinois Bond Court, you will see a great percentage of them have a lot of background. A great percentage of them actually do run. Colion, you're onto something, but this isn't it. This isn't even remotely close to being the worst parts of the bill. Oh, it's more worse. Talk about what happens with the anonymous complaints that anyone, and I mean anyone, can file against the police without a sworn affidavit. What? You mean the Sixth Amendment that guarantees you the right to face your accusers? Yeah, that part. Oh, there's far worse things to talk about. But don't fan the flames by clearly showing that you didn't read, because that is not what's in the context of this bill. You know what else is in the context of this bill? From a perspective of a person who's been falsely arrested by an overzealous police officer, it's the fact that the defendant, right, has the ability. Here we go. If the defendant seeks to call a complaining witness as a witness in its favor, it's able to petition the court for permission. Because you know, sometimes complaining witnesses do lie. And this is at the pre-trial hearing. Come on, man. There's good parts to this bill. There's great parts to this bill. And then there's horrible parts to this bill. Don't fan the flames by doing this, man. We expect better of you. Don't fan the flames. You do no one any justice when you fan those flames. This is Instructor Mike, and you've been freaking trained.